judgment and appeal in matters to the child.
Lord Wilson will give the judgment to the court.
This appeal is primarily about when a child loses his, or in this case her, habitual residence in a country. Whether on a particular date a child was habitually resident in a country is often important. For under a European Union directive and 2 international conventions to which the UK is a party, it is the court of the country in which the child was habitually resident which has primary jurisdiction to determine issues in relation to that child. Therefore, under the Family Law Act 1986, an application for what used to be called residence and contact orders, now called child arrangements orders, can be determined by a court here only if, at the time when it was issued, the child was habitually resident here, or, if not habitually resident in any other EU country, was present here. The appellant, a British woman of Indian ethnicity, had a same-sex relationship with the respondent, a British woman of Pakistani ethnicity. In 2004, they began to live together in England. In 2007, as a couple, they successfully applied for fertility treatment. The sperm of an unknown donor was introduced into the respondent, and in April 2008, she gave birth to the child, B. So B is British too. The appellant acted as B's other parent, both while her cohabitation with the respondent continued and, following her departure from the home in 2011, during her periods of contact with B. On 3 February 2014, without notice to the appellant, the respondent took B to Pakistan. She intended that they should live there indefinitely, and they've done so ever since. On 13 February 2014, not knowing where B was, the appellant issued an application for residence and contact orders. It was only 3 months later that she learnt that they'd gone to Pakistan. The appeal proceeds on the basis that, as a same-sex non-biological parent, the appellant would be unable to persuade a court in Pakistan to consider her case because of the strength there of negative attitudes towards that sort of adult relationship. In law, the respondent did not need the appellant's consent before removing B to Pakistan, but was B still habitually resident in England 10 days later, so as to give our court jurisdiction to determine the appellant's application? The lower court said no. They held that because of the respondent's intention that they should live indefinitely in Pakistan, B had lost her habitual residence in England at the time of their departure, even though 10 days later she had not by then acquired habitual residence in Pakistan. By a majority of 3 judges to 2, this court allows the appellant's appeal. It holds that B had not lost her English habitual residence by 13 February, and it directs the appellant's application to proceed. Our law about habitual residence is changing. 3 years ago, this court held that our concept of it should be governed by the test established by the court in Luxembourg, which requires there to be some degree of integration of the child in the environment of the country. The test is more child-focused than the one previously adopted here, which was heavily influenced by what at the relevant time had been intended by the child's parent. In 2 recent cases in relation to different aspects of the concept, this court has held that parental intention is no longer determinative in relation to a child's habitual residence. This now becomes a 3rd such case. It's clear that while it remains possible for a child to lose one habitual residence before gaining another, the modern concept expects that both will normally occur simultaneously. In relation to the present case, the task is to look at all the circumstances in order to see whether, by 13 February, B had achieved the requisite degree of disengagement from her English environment. And highly relevant to that task is to inquire whether by that date she had achieved the requisite degree of integration in the environment of Pakistan. Having completed that task, the majority concludes that on 13 February, B remained habitually resident in England. The appellant also issued a second application, which, so she contended, the court should exercise jurisdiction to determine because B is British. The lower courts rejected that contention too. Jurisdiction based on a child's British nationality stems from the old doctrine, still valid, that, like British adults, British children owe allegiance to the Crown, and that in return, by its judges, the Crown is obliged to make any necessary orders for their protection. Apart from observing that, while it must be exercised with caution, it is unhelpful to regard this jurisdiction as available only in extreme cases, we have no need to decide whether, in this case, the lower courts were right to decline to exercise it.